Hi, good morning, everyone, and thank you for joining us today for our annual labor law update. As you saw on the previous slide, if you have questions, you can use the Q&A feature at the bottom of your screen, and we'll address those at the end of the presentation. You also may have noticed that we extended today's time from 1 hour to an hour and a half. So if for some reason you can't stay for the whole thing, that's okay. We will be providing a recording at the end of the program that'll get out to you shortly and in the coming days. And so anything that you missed, you can go back and look at, and we will address those questions at the end of the program. So you may remember me from other updates or talking with me, but my name is Angela Toomey, and I've been the Director of HR at Morrison Garritano since 2015. And today I'm joined by Kristen White, Morrison Garritano's HR compliance consultant, who many of you also recognize. And Kristen brings over 2 decades of experience ranging from benefits management to payroll administration and other operations. And she's well versed in navigating complex regulatory environments. We also have with us today Nicole Cam, who is partner attorney of law with Fisher Phillips, and she represents a broad range of clients from small businesses to national companies, and she has experience in a variety of industries, defending employers against individual and class claims of discrimination, harassment, retaliation, wrongful termination, wage and hour violations, and she also has experience in both state and federal courts. So we have a packed agenda today, and we're going to talk through several either brand new laws or expansions on existing law that are coming our way in 2026. And then Nicole is also going to walk us through some of the real world cases from 2025 and highlight the impacts of those rulings. And then we'll again close with that live Q&A session. So just remember to add your questions in there. And please note, we do have a little bit of a larger audience today. And so if for some reason we don't get to everyone's questions, you can reach out to Nicole directly through Fisher Phillips, or you can reach out to the HR consulting team with Morrison Garritano. So to kick us off, in 2025, California introduced brand new employer obligations, updated regulations, and there were some key court rulings that really do require some careful planning for next year. And one of the things that we saw consistently, both in the case rulings as well as the new laws and new legislation, is that there is a emphasis on preparing ahead of time and preventative measures, stopping things before they happen. So many of the things that we will discuss might warrant updates to your policy manual, maybe your practices, and your payroll administration. So just keep those things in mind. I'll try to point them out, and we will as we go through each slide, but we do have a lot of material today. So always be listening in for those policy updates. So just to give you an idea of how busy the legislation has been in year one of their 2-year cycle, there were 2,397 bills introduced, and of those, a little over 900 went to the governor's desk, and 86% of those were actually signed. You can also see that the veto rate was slightly lower than the 10-year average, which is normally about 15%. So, okay. And let's start off with minimum wage, and we're going to turn this over to Kristen.
Thanks, Angela, and thank you all for joining us. As she said, our first topic today is minimum wage. As published a few months back, the California-based state minimum wage will increase to $16.90 per hour. As part of that FLSA exemption test, you may have exempt employees to make sure you're paying them twice the minimum wage, and they base that on 40 hours. So that calculates to just over $70,000. So that's a minimum you'd have to pay somebody as part of that exemption test. On the slide here, we also included the amounts for inside sales exemption and the tool rate. So action items for you. First, ensure all your employees are increased to at least the minimums. Second, we do recommend you review employees that are at or slightly above the minimums, and consider an increase for them too, or at least be prepared if those employees ask questions. Continue with minimum wage. As we're used to, many cities have higher rates, and some even have separate paid sick leave requirements. So I won't go through each one of these, but know this chart is here for reference. You can also refer to the HR compliance section in Mineral. Now we'll move on to new laws and regulations. AB 692 is our first one today. Fortunately, this one does not add a new requirement. It actually bans a practice going forward. Some use what they refer to as stay or pay agreements. I mean, you give something to the employee, but you include a rule the employee needs to stay, meaning stay employed, or they must pay you back upon leaving the company. So going forward with new agreements, this is no longer allowed. There are a few exceptions you can see listed here on the slide. This one can get nuanced and be subject to class action. So if your company does use these type of agreements going forward, you may want to run them by an employment attorney. Next, we have SB 642. This updates California's pay transparency and equal pay laws. So for each position you have posted, employers must include a good faith estimate of the pay rate or range they reasonably expect to offer upon hire. That's a mouthful. But previously, the law just said that you should share what you reasonably expect to pay for the position. So this new version is just a slight nuance to get more specific. The bill also amends the Equal Pay Act by extending the statute of limitations. So the action item here for you is to ensure the pay ranges in your job postings reflect the amount you actually intend to pay upon hire. Next, I'm handing it back to Angela.
Okay. Okay. So just when you thought COVID regulations were in our rearview mirror, we do have something to be mindful of. Back in 2021, you may recall that the law required you to first call back anybody that was laid off due to a COVID closure or restructuring before you went and hired from the outside. And that was actually set to expire at the end of this year. But now these protections for very specific industries, which would be hotels, private clubs, event centers, airport hospitality operations and airport service providers, and building services for commercial buildings, these protections are now extended to 2027. So if you did lay off employees during COVID after a certain date, which I'll show in the next slide, you are going to have to first go back to those employees. And the rehire rights center around, as you can see, that it has to be after May 4th of 2020 that the layoff occurred. So if it was sometime in that first quarter of 2020, this doesn't apply. But anything after that, and if you're in one of those industries, you want to make sure you're focused on this. And your obligation here is to notify qualified employees in writing within 5 business days of any job openings and offer them reemployment. And you would do this in order of seniority. So you would go back to your employment records and see who was laid off in order of who was there the longest and start calling those people first. And again, the industry matters here. You have to be in one of those industries, as well as that timing that it needs to be after March 4th of 2020. But if it does apply to your company, you want to be sure and comply because there are potential penalties for non-compliance. Okay, so getting into this one, Know Your Rights Notice. This does require some new action, and there is quite a bit packed into this one. So I'm going to try to go over most of it in detail. And most of this bill is aimed at unfair immigration policies. And you're going to see some overlap with other data that we currently include in our employee communications, but This doesn't replace your wage theft prevention notice or anything else. So this is a unique notice that is going to be required. And the labor commissioner is set to post something by January 1st, some kind of a model notice. And then there is also slotted to be this summer in July, which is optional, a video that could be paired with that notice. But the video part is optional, the notice is not. And so the notice requirements don't start until February 1st. So that means that you're going to want to get this out before February 2nd or thereafter upon hire. And then it's also provided annually after that. So another one that do it all at once when it's initiated in February, whenever somebody new is hired, as well as an annual notice to all employees. So, as I said, the intent of this was to make sure that California workers have a strong understanding of both their workers' rights as well as their constitutional rights. And so this notice is going to include information on some things that we're used to providing already: workers' compensation benefits, wage and hour laws, health and safety, paid sick days, unemployment. But some of the newer things are these are requirements of relating to if you have any notice of an immigration action happening. So say, for example, you got a notice that your I-9s were being inspected. You must provide this information to employees within 72 hours of receiving that notice that you're going to have the inspection. And there are certain things that have to be in there, and it also includes a copy of the actual notice that you got from that entity. So that is one brand new thing. It also provides protection against unfair immigration related practices. So these have always been around. Well, not always. If you don't remember those rules from 2018, now is probably the time to start looking at those again. And these are the things like you can't ask for an ID that is more than the federal government allows or requires, or that's different than what the federal law would require, or refusing to just accept a document that appears genuine on its face value. Any misuse of e-verify, like running someone's e-verify, not because they're a new hire, but just randomly, firing or threatening to file a false report with ICE, or simply just threatening to call ICE if that employee is exercising their rights. The other thing that is baked in here that I do get calls on about is like when an employee attempts to update a lawful change in their personal information. So let's say you have someone working for you, and then one day they come in and say, hey, here's my new Social Security card. This is something you cannot retaliate against them for. And again, if it appears genuine on face value, you update the records. You don't retaliate like, well, gosh, it looks like you had a different Social Security number before, and now how can you have this one? It's a lawful change. It's a lawful change. The other new thing that's coming out in this notice is the right to organize a union or engage in protected activity in the workplace. And there's also information here about your constitutional rights when interacting with law enforcement at the workplace. So this is something completely new that we've not seen in the past. But basically, what one of the components is you need to, by March 20th of 2026, you need to allow for employees to designate an emergency contact, which most of us already do that. However, this emergency contact is unique because if the employee would like you to, you're going to designate that specific contact as someone who you would call if the employee were arrested or detained while working. And this could be at the work site, it could be at a remote job site. As long as the employer has actual knowledge of the arrest or detention in the course of duty or work, this would trigger that situation where you would want to go to that emergency contact and identify that the person had been arrested or detained. So if you don't have emergency contacts, you want to find a system or a way to keep that, and then having that special identifier or a place to make a note as to where the employee might want you to call someone in the event of their arrest, or detainment. Okay, so there's still a little bit more here to go. So employers need to provide this notice in a language that's normally used to communicate employee information to that employee. And you can also do it in English if there's no translation available in the language you would normally use. It also requires, as we talked about, we talked about the arrested thing. And as you can see, noncompliance can result in civil penalties up to $500 per employee per day, with a maximum of $10,000 per employee. And this is pretty steep. And the other thing to remember is that because this is under the Labor Code, Labor Commissioner jurisdiction, this could also be one of the violations that someone could allege in a PAGA lawsuit. So definitely not something you want to take lightly here. And that is the Know Your Rights notice. And just while we're on the subject of things we're going to give employees, as you may remember from last year's update, the crime leave victims' rights were expanded. And so this year is the first year that this notice is sort of on the annual compliance, because this one also, it goes to employees upon hire. It goes to employees if there's some type of incident of like a leave triggering incident, like you've become aware that someone might be a victim of a crime. And the second thing is it just comes out every now annually you have to provide it. So you will add this to your list of annual notices. And this again, the crime victim leave law was expanded to allow employees who are victims of very certain crimes or have family members who are victims or any designated person to take time off work, to attend any judicial related proceeding. There were many, many things that fell under this. And the definition of family member was also expanded to include the employee's grandparent, grandchild, domestic partner, and any, of course, designated person, our favorite one in California. And you can see that that list of crimes was expanded from just being a victim of assault or stalking to add serious bodily injury, threat of injury or death, and other crimes just resulting in like maybe a death of a family member. And we do want to keep these compliance records for up to 3 years. And that would be including the dates that you provided these notices. And I'll also just note on here that paid sick leave expands to match this, because when the paid sick leave can be used for this type of leave, so when the definitions expanded, so did the paid sick leave reasons for use expand. So you might want to look at your policy to see if it has all those things in there as well. And that is it. And we have a bullet there on where the notice can be found. Okay, data breach notifications. So this one applies to an individual or a business that conducts business in California and that owns or leases or licenses computerized data that includes personal information. Personal information is defined pretty broadly to include things like social security number, driver's license, debit credit card information, that type of thing. And before this law, the notifications of data breach had to be distributed without reasonable delay. And now that has moved to, we have 30 days from discovering it or being notified of the breach. So there is some flexibility to accommodate the practical realities of a data breach incident. For example, your response could be delayed because you need some kind of law enforcement interaction where they're investigating the situation as well. And so you might not release it to the public while you're still doing that, cooperating with law enforcement. And also too, you might need to determine some time to figure out how big the breach is, also restore your system so you can notify people. But integrity must proceed promptly once those needs are removed. So as soon as you reasonably can, that's when you have to, that 30 days would kick in. Those are the only exceptions. So be mindful of that. And this one on personnel records, it seems light, but when you read into it, it can be some heavy lifting if you offer a lot of learning and development in your organization. So right now, personnel records, as you know, California allows current and former employees or their representatives the right to inspect or receive copies of their personnel file that relate to their performance or any grievances. And, there's time constraints on that. Employers are required to make these records available within 30 calendar days or a written request and maintain those personnel records for at least 3 years after you've parted ways with the employee. So that is what you currently have to do. But now that definition is expanded, as you can see in our next slide, because it adds education and training records to the definition of the personnel file. So, and it said here, our CFO, he read this labor code himself because he wanted to really understand about, it says, if you maintain education or training records, well, then this law applies to you. So I think most of us do maintain education and training records because we have our anti-harassment compliance and things like that. But if you have them, then now you have to make that part of the personnel record, or it becomes part of the personnel record. And you're going to want to carefully document the name of the training, the provider's name, how long was it, what were the learning objectives, if there was any certification or anything at the end, you want to have that included in there as well. And these records would still need to be made available within that existing 30-day window of a written request. So if you have a lot of training, like for example, who knows that you're here at this training right now? Is it being recorded? Is it being documented? Probably not. So this is the kind of thing that you would need to think about so that if someone ever had to prove what they had, what education or learning they had, that they could. So, and then there were also some updates to the WARN notices. And just a reminder, WARN is something that exists at the federal level. And then there's also the Cal WARN, which is the California version. And a covered establishment under WARN is any industrial or commercial facility or part thereof that employs or has employed within the preceding 12 months 75 or more people. And that's the more strict definition, the one you want to follow. The federal is 100, but because we're California, you want to look at that 75. And this act is triggered by mass layoff, closure, or relocation of a business. And so before this happens, you must provide 60 days advance notice to employees, state agencies, local officials, and they have provided the criteria of what kind of notice needs to go into this when you're notifying employees. And this is probably one that you might want to partner with an attorney on for many reasons, but even something like doing something like a disparate impact analysis before you make your decisions is probably a conservative thing to do. And then some of these warn change notices that you have to put out to employees, these are the things that you'd want to include. You're going to talk about whether or not you're going to coordinate services such as rapid response, orientation, and through which entity. Oftentimes that's going to be the Workforce Development Board here locally. You want to include your email, telephone number of the local Workforce Development Board, so that's where they can find other employment resources, as well as education and training. You want to have a description of the rapid response activities offered by workforce development boards, again, such as training or job placement services. And also in there is a lot of information about CalFresh, such as a description of what it is, the benefits helpline, the email and telephone number of the employer needs to be included, the CalFresh website. And so if you do plan to coordinate with your local workforce development board, then you want to arrange that service about 30 days ahead of time. I'm actually on the SLO County Workforce Development Board and would be happy to provide any information that you need on this or the rapid response program. It's really a great resource for employers who are faced with this difficult situation. And so that is that on the WARN Act. And with that, I am going to hand this off to Nicole, and I'll be back later.
Thank you, Angela, and thank you, Morris and Garitano, for having me. Everybody listening, it's great to be back. So the next bill talks about a extended statute of limitations for sexual assault claims. What it does is it reopens the window for adult survivors of sexual assault by extending the statute of limitations to through December 31st, 2027. The way that this impacts employers is if there is an institution that was involved in a cover up or some sort of issue involving a sexual assault claim, it potentially reopens up the window of time for an individual, an adult, to bring those claims forward. Previously, the window was only open for individuals, not for entities, and now the idea is to align those two things. So hopefully this does not apply to anybody that is in the audience today, but if it does come up, you should be aware that we can't just rely on the fact that there's a statute of limitations bar, because now those statute of limitations have been reopened. And again, the statute of limitations is the time that an employee or an individual has to bring a certain cause of action. And they vary depending on the types of causes of action. And what this bill is doing is it's allowing an opportunity for those who may not have had the opportunity or the ability in the past to bring a claim forward, to bring those claims forward now during this period. And it's not an indefinite window. It's only from January 1st of the coming year through the end of 2027. And it does not apply to public entities. The way that this potentially impacts employers primarily is that it also revives claims related to or arising out of the sexual assault, such as a wrongful termination or a sexual harassment claim connected to the assault. So just keep it in the back of your head that if a claim comes forward that you think might be time barred or might have happened quite a long time ago related to a sexual assault, that you should talk to counsel about that, because it may fall within this window and there may be an opportunity for that individual to bring their claim forward, even if it's many, many years old. The next topic is AB 5 exemption extensions. And the exemption extensions are fairly narrow. But what I wanted to do is take the opportunity to just give a little bit of a kind of reminder about independent contractor status in California. So if you've been tracking kind of the progress over, I would say now we're probably 7 going on 8 years, you're probably familiar that about 8+ years ago, we had what was called the Borrello test in California. And the Borrello test had a set of factors where we would look at those factors to evaluate whether an individual could fall into an independent contractor classification or was an employee. And it's important to keep in mind that under the law, the presumption is that all workers are employees, and the burden is on the company to prove an individual's an independent contractor. So we're always going to start with the presumption that the individual is an employee, and then think about, can we fit the person into an independent contractor status that falls under the current law. So in years past, we had the Borrello test, and then we had a case called Dynamics, which adopted the ABC test, which came from a couple of states on the East Coast. And what happened after the Dynamics test is now we had a kind of a split in authority, a split in case law. And so California's legislature passed a bill, AB 5, which codified the ABC test for purposes of the independent contractor analysis. So now instead of the Borrello factors list, and the primary factor in Borrello and the number one, the A factor in ABC, is the amount of control that the company has over the individual. Are you telling that individual how to do the work, when to do the work, using what methodologies, using what tools and equipment? Or are they coming in with a distinct skill set, already trained, their own tools and equipment, providing those services to others in order to really truly be an independent contractor? So after AB5, AB5 was amended under AB 2257, adding some specific subcategories for exemptions. And then now it's being slightly revised again to extend the exemptions for licensed manicurists and commercial fishers. So it is pretty narrow, but there is a continued ongoing exemption through the dates stated here, 2029 and 2031. I can't believe we're already talking about those dates. For the individuals in those categories. But what is the real takeaway here is that it's important to very, very closely analyze and potentially go and audit any individuals you have performing independent contractors, being paid by 1099. Make sure, number one, that they have a written independent contractor agreement in place that's signed. That independent contractor agreement should state the terms of the agreement, the payment terms. It should be drafted to have that individual potentially fall into one of the categories under AB 2257 and AB5 for exemptions. For example, business to business services. Certain professionals can fall into that category. Certain event people that perform at events or one time, kind of like maybe the band you have come at play at your wedding type thing. But it's very, very specific what those exemptions are. And if the individual does not fall into those exemptions, or if there's no clear written agreement, or if there's too much control over the individual, then it's more likely that they'll be found to be an employee and you could be liable for timekeeping and overtime and breaks and pay stubs and everything that is required of employees. So it's a good opportunity to go back and audit your classification. It's also, going back to what Kristen was talking about, the minimum wage. While you're doing that, I would do a exempt, non-exempt audit and make sure that all your exempt employees are properly classified, especially in view of the increased salary threshold. Okay, next topic is the Labor Commissioner enforcement of tip claims. If you are in an industry that has a more common occurrence of tips, it's important to listen to the information here. So we're talking about usually hospitality industry, we're talking about the restaurant industry, we're talking about other industries as well where tips might come into play. This is different than a holiday gift. It's different than some sort of perk or benefit. Under the law, tips are the property of the employee. So tips that are left for an employee belong to the employee. They cannot be kept by the employer. They cannot even be split with the employer. If you have a tip pool, which is permitted, it must be reasonably defined as to who can participate in the pool. It has to have a clear distribution formula that is fair and reflects the service contribution. So if you're a restaurant and in your tip pool, you have the host and you have the busser and you have the dishwasher, all of those individuals should have the contribution to the service, and then the distribution should reflect the work that was performed and be laid out. And you want to make sure that managers, supervisors, and other agents of the company, of the employer, are expressly excluded. What this bill does, allows the labor commissioner the power to investigate, issue violations, and pursue civil actions against employers for tip violations. It also allows employees to file claims with the labor commissioner for failure to properly provide tips, failure to properly or timely pay tips that are made by credit card. You can't charge an employee the credit card fee and deduct that from their tip. So now there's another avenue for employees to try to recover or raise claims related to their tips. This also includes a potential civil penalty, potentially under PAGA, which I'll talk more about in a bit. And those penalties range from $250 per violation to $1,000 for a willful per violation for willful violation. So those numbers can get fairly high fairly quickly. The recommendation and the takeaway here is that you do want to maintain detailed records of gratuity transactions, tip pool distributions, and credit card processing fees, so that if a claim is ever raised, you have the documentation to demonstrate compliance. So along with the kind of audit list that I'm going to suggest and the takeaways for today, if you do have a tip pool policy, add that to your audit list to review going into the new year. I'm going to hand it back over to Angela to talk about the next topic.
Thank you. So I'm going to talk a little bit about some of the pay equity updates. And the first one is our California pay data reporting. And if you are a covered employer, that would be if you're a private and over 100 employees and labor contractors total with more than one California employee, either one of those two, we got both those definitions up there, or you report to a California establishment, then you would need to do this report. So you can see the first one is payroll employee report and labor contractor employee report if you have those labor contractors. So they're going to be separate, which I'll talk about in the next slide. But so if you have over the 100 and the full and part-time workers are figured into the calculation the same. It's not by FTE, it's head count. And the other thing that you want to be mindful of is your integrated enterprises, because those would be included in that calculation. So an example of an integrated enterprise would be like, Disney. They have streaming service, they have amusement parks, they have theme parks and media networks, film studios, but what they have in common is common management, common HR policies and things, related operations and branding and central control over unions or labor relations, and also common ownership. So you want to think about that when you're factoring in your definition of, or you're calculating if you meet that 100 or not for any integrated enterprises. And this report is due by May 13th, and it only can be submitted through the California Civil Rights Department portal. There's no other optional reporting method that I'm aware of. And just looking at some of the things that you're going to be reporting on the next slide, you'll see that you're going to report your job categories, which is your standard 10 EEOC categories, and then your pay bands, which come from BLS, Bureau of Labor and Statistics. And then you're also going to have the race and ethnicity category, which includes the new one, which is Middle Eastern or North American, or I'm sorry, North African. And then you've got your sex, female, male, non-binary. You'll need to also be ready to report on the hours worked, which includes any leave that they took if they were paid for the leave. And then you're going to take that, your mean and median hourly rates by job category, by pay band, by race and ethnicity and sex, and that all gets reported through. There's also an indicator for remote workers, and that's pertaining to remote workers in California. So if you don't already track your remote versus your non-remote, even in your remote, you want to distinguish between California remotes and just remotes in some other state, because the California ones are the ones that we're going to put into that report. And then, as I mentioned earlier, there's separate reporting for, you've got one report for your regular employees, and then if you have labor contractors or supplied workers, you're going to do one there. And you're going to need to basically identify your labor contractors, as Nicole has been talking about, and you're going to need to get this data from them. And they are required to cooperate, but you can imagine it might takes some time. So as we talked about earlier in the beginning, this really is about planning. And so some of the considerations in the next slide would be before you file, just make sure that your headcount thresholds and all those things are require you to file, including any integrated enterprises. And then you want to pick your snapshot period that you're going to use. It's going to be sometime in Q4, but you want to pick that, and then you're going to also potentially consider conducting some privileged pay equity audits uh, by job category. And when I say privileged, I mean with your attorney. You could certainly do it on your own, but if you do self-audit and that information is not protected, and you found something and you didn't correct it, then you could be exposed to further liability. So I do recommend in that case you partner up with your attorney to do that. And you want to the best of your ability, ensure accurate self-identification for the data that you have, whether it's race, ethnicity, sex, and then you want to, again, track that remote worker status. You'll also be coordinating with, if you're part of a PEO or if you outsource any of your HR, your staffing vendors, you want to just start thinking about this early so that you can get that data. And this is data, again, you want to retain for 10 years. And the Civil Rights Department can pursue court orders and civil penalties for misfilings. And the individual data that they collect is confidential, but aggregate data is published annually. So for your next steps, you want to schedule that Q1 data preparation, which would be ready for that submission, which is going to be in May. So you want to align your federal EEO1 and any California reports for consistency, and maybe just take a look at your pay transparency postings. That's under SB 1162, but I still see everyday job postings that don't have any wage information on them. So want to be really careful of that. So having said all that, I am going to hand it back to Nicole.
Thank you. Okay. Next topic is the California Consumer, it's actually Privacy Act. I apologize for that. So the CCPA. Now, this topic is a whole practice group in and of itself at my firm. So I am only going to speak very high level on this, but if you have any questions, if there are any areas that you think this impacts your company, even if you just have a high level privacy issue come up. For example, a client reached out yesterday about recording and monitoring employees in the workplace, whether by camera, whether taking photographs, audio. Those are all things that you want to make sure are on your radar and that you're addressing appropriately when it comes to having policies, setting out expectations related to privacy, and having notices and disclosures where required. We're seeing a lot more litigation in this area, a lot more claims coming through. And as we go forward and these new laws continue to be passed and the future of AI becomes more prevalent in our day-to-day, I definitely foresee more of these becoming part of our daily advice and counsel and our litigation that we see. So the first topic here is automated decision-making technology. We still have some time to prepare for this, but by 2027, companies must tell individuals when AI is used to make significant decisions like hiring, lending, access to services, and allow an opt-out. In the employment context, these decisions also include hiring, assignment of work, salary or hourly per assignment compensation, incentive compensation, promotions, demotion, suspension, termination. If a company is using AI either to help make a decision, to compile documentation regarding a decision, or information or data regarding any of these decisions, then there are certain requirements that will be in place at that time. This does also apply to not just employment opportunities, but independent contractors. So that's a theme that we continue to go back to, is make sure that you're aware of what the obligations are for independent contractors as well. And then a risk assessment will be required when that automated decision making is used in those significant decisions. On the next slide, I'm going to tell you about a real life lesson from a recent CCPA enforcement situation. So this was the first action by the California Privacy Protection Agency, so the agency that enforces the CCPA, the first action addressing privacy obligations related to employment and applicant data. So we're talking not just about employees, we're talking not just about consumers, but we're talking about applicants as well. And as you know, a lot of the laws like FEHA and anti-discrimination, anti-harassment, those laws not only apply to your employees, they apply to applicants, those just expressing interest in working for your company. So in this situation, this company, Tractor Supply, was fined $1.35 million in September of this year because they didn't provide job applicants with a clear privacy notice. They didn't inform job applicants on their rights and how to exercise them. They didn't honor browser-based opt-out preference signals, and they lacked compliant contracts with third-party vendors. So that was a pretty large fine. And along with the fine came a directive from the agency as to what they had to do going forward. In California, the privacy notices are for applicants and employees, not just consumers. You want to make sure that you're reviewing and updating your privacy notices and that opt-outs are actually working. So again, kind of on the action item list, I really like this time of year to review your employee handbook, to review your policies, and to conduct these audits so that if any changes have to be made, you can implement them in Q1 of the next year. And it kind of makes sense. So if you are issuing a new handbook, if you're issuing a new arbitration agreement, which I'll talk about, any new documents of any kind, New Year usually makes sense in terms of timing. We've reviewed, we're doing our annual review, we've made some updates based on changes in the law, we're circulating our updated agreements, our updated handbooks and policies, and it tends to land a little bit better than it could if you pull it out mid-year or towards the end of the year when maybe employees are less likely to expect that. And then the last topic is regulations on automated decision systems. So it's a little bit familiar or similar to what the first topic was that doesn't come into play until 2027. But this is currently in effect. This is in effect as of October 1, 2025. It applies to employers or vendors regularly employing 5 or more individuals, and essentially extends FEHA's anti-discrimination rules to AI and automated tools used in employment decisions. So if you're using AI to screen resumes, to comb LinkedIn, to come up with questions or feedback for an applicant, you want to make sure that you're complying again with these rules, that notice and disclosures and opt-out opportunities are all in place. And this applies broadly to all employment practices. So it might be something that maybe you're not even thinking of front of mind, but if it has the potential to discriminate based on a protected category, then we need to make sure that we're in front of it. On the next slide, what you have to do to comply now. You must ensure automated systems do not directly or indirectly discriminate based on those protected categories. And in California, we have a long, long list of protected categories, including race, sex, age, disability, pregnancy, veteran status, requests for accommodation. The list is very, very long, and it continues to grow. You want to increase your record keeping and retain personnel and related records for at least 4 years. Prior, under these laws, it was 2. I always recommend keeping personnel files, payroll records, and time records for at least 4 years. And the reason is, going back to the statute of limitations, for many of these claims, You can go back 3 to 4 years, so a minimum of 4 years, so that you make sure you have that documentation available if you need it. And then bias testing is recommended but not required currently. Conducting bias testing, ongoing monitoring, and human in the loop reviews, so that you have an actual human reviewing anything that AI is assisting the company with. So again, this is a very big topic. If it's anything that touches your company in any way, or if you have questions, please do reach out. We have a fantastic team in place that advises on this, litigates on this issue regularly. Okay, the next topic is PAGA reform. So this is, I just wanted to loop this in, even though the reform passed in the middle of the year last year. We had the 1 year anniversary in July 2025, and I did a presentation on kind of the impact of the reform 1 year out. If you don't know what PAGA stands for, or if you've not heard the term PAGA, I always say consider yourself lucky. PAGA stands for the Private Attorneys General Act. It's similar to a class action in that one employee can bring a claim on behalf of themselves and all other alleged aggrieved employees. But it's different from a class action in that it does not have to be certified. It does not have to have all the requirements for a class action, like commonality and typicality. On the flip side, with under PAGA, you can only go back 1 year, as opposed to a class action where it's generally 4 years. Now, the claims that are brought under PAGA are claims for civil penalties under the Labor Code. So we're talking about the minimum wage, overtime, record keeping, meal and rest breaks, all the nuanced ones like reporting time pay or split shift pay or suitable seating or temperature. Anything that you find under the Labor Code or under the IWC wage orders is fodder for a potential PAGA claim. In order to take advantage of the reform that was passed last year, employers have to take all reasonable steps to comply with the Labor Code. And what that means is that, or at least an example under the statute, is have lawful written policies that employees receive. So we talked about updating your employee handbook and your policies. Training supervisors on legal compliance. The supervisors are your first line of defense, and so they have to understand the law, they have to be well trained on how to enforce policies, they have to know when to elevate to HR or to your HR partners at Morrison Garritano or wherever that you have that extra support, maybe your legal counsel. Conduct periodic payroll audits and take action in response. So pick a pay period and pull all of your time records and your payroll records, either a pay period per quarter, or if you're really large, just a sample pay period in the last year even, and review all those documents. Line up your time cards and your payroll records and make sure that they reflect that all wages were paid, that there's no overtime that wasn't paid, that your pay stubs have all the requirements under the law, that you're factoring in any additional compensation in the regular rate of pay. And I'm going to talk more about that in one of the cases for overtime purposes, also for meal and rest break penalties, also for paid sick leave. When I say regular rate of pay, I'm talking about all compensation divided by hours worked. So if you have commissions, if you have non-discretionary bonuses, those get employers in hot water a long time. A couple of years ago, I had a case where the company would give employees basically a guaranteed Ralph's gift card during Thanksgiving for a couple $100 so they could buy their Thanksgiving dinner. And the value of that gift card, because it was non-discretionary, had to be factored into the regular rated pay for those purposes. When I'm talking about meal and rest break premiums, if there is a situation where an employee is not able to take a timely or a complete meal or rest break as required by law, a penalty has to be paid. And that penalty is an additional hour of pay for every day that the break is missed, just one penalty per day, per meal break, per rest break. So even if the employee misses 2 rest breaks, they only get 1 penalty, an additional hour of pay at the regular rate of pay. That should be itemized separately on the employee's pay stub so that if there is litigation or if it's ever questioned whether an employee received a penalty, we can prove it because it's shown on the pay stub. You can have a break penalty or break premium line item. If you're really diligent and you're tracking both your meal breaks and your rest breaks, you can, and paying premiums, you can separate meal break penalty, rest break penalty. But it is important to pay those from time to time because because there's case law saying that if an employer never pays a premium, that could be a unfair business practice claim because it's almost impossible to be 100% compliant. And 2, so that we can show that we've taken those reasonable steps to comply with the law. And then take action if when you do your audit, you see that there's unpaid overtime. You see that there's changes that have to be made to the pay stub. You see that meal breaks are not taken, they're not starting before the end of the 5th hour of work, or they're 29 minutes instead of at least 30 minutes, that you're taking action in response. And take action with regard to supervisors who are not enforcing policies or not complying with policies, because again, that's where we are going to get the issue. If you do that now before you ever receive a PAGA letter or arguably a request for records that Angela was talking about, a personnel and payroll record request, we can argue in litigation that penalties under PAGA should be reduced up to 85%. If you do it after you receive a PAGA letter, we can still argue, but it's up to 70%. So this has really been significant for us doing wage and hour litigation and working with clients to be proactive and be compliant early so that we can be in the strongest position possible in the event of a PAGA claim. And honestly, this is going to serve you if there's a labor commissioner claim, if there's a class action, if there's a single plaintiff, even if you're being diligent about all these steps, you're going to benefit in the end. And again, great time to conduct a PAGA audit. We have a team that does it. We also provide resources if clients want to do it on their own. One of the benefits of doing it with counsel is it can stay privileged until you determine what you want to reveal or release. So if we do the audit and there's a lot of issues, we don't necessarily want that all to be discoverable, right? We want to protect some of that. So the takeaway from here is that make sure that you are really diligent about your wage and hour practices and take those reasonable steps and do it in a way that if we ever need to use it as a defense to reduce penalties, that we have that available for us in litigation. Okay. I'm going to spend some time now going over a couple cases. Now, cases come down daily. Every day I get alerts from the different courts about cases that have come down, employment law cases, all different topics. And cases are helpful because what I like to do is I like to pick cases that are kind of representative of most of the situations that I see come up on a day-to-day basis and use them as reminders and kind of provide additional information for you to take away and keep in mind as you go forward. Unlike statutes, which are generally prospective, generally they only apply from the date of effect going forward, cases can be retroactive. So you might be utilizing some sort of practice and a case will come down and say, what you've been doing is actually not lawful and you should have been doing it this way all along, even if the law at the time said otherwise. And I've actually had that situation in the middle of a lawsuit where case came down and basically blew up our position. So cases are helpful because they give you insight into how a court or a jury is going to view a case, reminders about implementing day-to-day practice items, and then how to handle certain situations that come up in the workplace. The first case is Lister versus City of Las Vegas. This is a kind of unique case because the The result was not what I would have expected. And this was in the Ninth Circuit. If this had been a California state court, I probably would say that we would get a different result. But in this case, the plaintiff, Latonia Lister, was the city's first Black female firefighter and had worked for the city for 29 years. She was on duty when her supervisor, a white male, began feeding his dog pieces of steak in front of her, telling the dog, "Here, girl, here, Latonia," and making kissy noises. Lister sued the city for sex and race-based discrimination and retaliation, and the case ended in a jury trial. The jury found that the incident was severe and pervasive and objectively and subjectively offensive, but that Lister had not been discriminated against or retaliated against on the basis of her sex or race. So there was no liability because the conduct was not based on a protected category. So remember, when we're looking at these situations, or if we have somebody come to us with a complaint or a concern about the workplace, we certainly want to address every concern that's brought to our attention, but some are going to be handled differently than others, or maybe have a different result if they're not necessarily based on a protected category. You know, if somebody says, "Oh, I don't like your shirt today," that's not protected. If it's targeted at that person because they're female or because of their race, that is protected. So in this case, the Ninth Circuit reaffirmed the district court's determination that the jury found the dog feeding incident severe and pervasive, but not racially or sexually discriminatory. So therefore, there were no damages awarded, and there was no liability in this case. As I mentioned, I do believe that this is something that could go the other way very easily. It's very expensive to litigate a case all the way up to the Ninth Circuit. And I'm talking, when you get to that point, you're talking probably seven figures in attorney's fees. So the takeaway here is that we don't even want to get to the point where we maybe have litigation, and we want to be addressing these situations early. If this is something that's brought to your attention, you're conducting a prompt and thorough investigation, you're responding appropriately, you're following up with the complainant, you're doing all the heavy lifting that you need to do to try to mitigate a potential claim. The next case is Krutbosch versus Bakersfield Recovery Services. And this is also a sex harassment claim, but this one took place outside of work for the most part. Krutbosch was on a bereavement leave. Krutbosch is a male, on a bereavement leave for the loss of his partner, when a female coworker began sending him unsolicited, sexually explicit text messages. Eventually, the coworker even went to Krutbosch's home uninvited to proposition him and offer him drugs. When Krutbosch returned to work a week later, he reported his coworker to his employer's acting program director and HR representative. Both told him there was nothing they could do because this action took place outside of work. Krutbosch and the coworker did not have any further interactions, but Krutbosch resigned after 1 week back at work, citing that his employment had become unbearable. In addition to these facts, the HR person posted a video on social media the day that Krutbosch had complained to her. The video was of whining dogs, which he took to mean that that was in response to his complaint that he brought to her attention. He thought he was being mocked. And the fact that the company took no steps to address the situation, which took place outside of work, but impacted an individual who'd returned to the workplace. So Krutbosch quit, but he filed a suit for hostile work environment, sex and gender discrimination, retaliation, failure to prevent discrimination, constructive termination, which is when somebody quits because they say that the circumstances were so intolerable that they couldn't stay in their job, and negligent hiring, supervision, or retention. The case was initially dismissed after the trial court granted the defendants demur, and then Krutbosch appealed. The Court of Appeal ruled that a hostile work environment claim was viable based on the theory that the defendant's response to the complaint about the coworker's offsite conduct changed his working environment in an objectively severe manner, but said that the theory of his coworkers' offside conduct being harassment could not be imputed onto the company. There's a couple things that I want to point out here. The first is that the coworker was not a supervisor or a manager, just a peer. Supervisors and managers basically stand in the shoes of the company, and there's strict liability. So if it had been somebody in that role, very likely the company would have been on the hook. That's number one. Number two, the hostile work environment claim is still viable. So the court said, even though this conduct occurred outside of work, the impact on the workplace was sufficient enough that the company should have taken action, investigated, followed up, maybe disciplined the employee, maybe separated the two employees in some way. But really, employers need to know to take all employee concerns seriously and follow up in some form or another, because it's very likely that a case will turn into a bad result if we show that the company just dismissed and didn't take seriously and didn't take any action to address the complaint that was brought to its attention. Now, again, the scope and extent of an investigation is going to depend on the particular complaint that's brought to your attention, but every single concern should be looked into and resolved in some way as appropriate for that consideration. The next case is another sex harassment case, Carranza versus the City of Los Angeles. Carranza was a captain in the Los Angeles Police Department when she discovered that a topless photo of a woman purported to be her was being spread among officers. So it wasn't her, but it was purported to be her, and it was being passed around to what she said was dozens, if not hundreds, of officers, many who viewed the photo on duty and made lewd comments about Carranza. Carranza made a sexual harassment claim and the LAPD initiated an internal investigation into the photo. She asked that the department issue a notice that sharing the photo was inappropriate and find the source of the photo, but the department declined to do so. Carranza sued the city, asserting one cause of action for hostile work environment. And at trial, the jury, and again, here we are back in LA, back in California, and this is the result that I would have expected, unfortunately. The jury ruled in Carranza's favor and awarded her $4 million on that. The City of Los Angeles moved for a new trial, arguing there was insufficient evidence of severe or pervasive. So in order to be unlawful, harassment has to either be severe, really, really bad, assault, a really bad word. There was a case a couple years ago where a single use of the N-word was sufficient enough. So it could be one incident, but it has to be pretty serious. Or pervasive, a pattern of harassing conduct, a pattern of intimidation or comments or jokes or whatever it happens to be. The Court of Appeal denied the city's motion, finding that Carranza's contention was based on her reasonable understanding that the photo had been circulated for a continued length of time, and here involved dozens, if not hundreds, of officers throughout the LAPD. Carranza also established that the LAPD allowed the distribution of the photo to go unchecked, which resulted in her working conditions being altered and making it difficult for her to do her job. So she had made repeated requests for the department to take action, and they didn't. Her requests seemed pretty reasonable, right? To say that this shouldn't be spread any further and to put officers on notice that their conduct was not acceptable. It's also important to remember that harassment can include rumors, it can include images, it can include disrespectful behavior. And here again, we're seeing how an employer's failure to act created a situation of pretty significant, in this case, liability. So the takeaway is make sure that we're taking action in response to these complaints. If there's ever a situation that's outside of what you feel comfortable handling, reach out to Angela and Kristen, reach out to your legal counsel and get support in it, because it's very important that it's properly handled and documented so that we can prove the steps that were taken if ever needed. The next case is a religious accommodation case. So this again is having to do with post-COVID-19 and an employee whose employer required the use of both COVID testing and then COVID vaccination. So you can see how long it takes to litigate these claims. COVID, we're going on to almost 6 years post-COVID, and we're just seeing these cases be litigated all the way through trial. In this case, the plaintiff was a practicing Christian who believed her body was a temple and that she has a religious duty to avoid taking substances condemned by the Bible. Detweiler sought a religious exemption from the mandate requiring healthcare workers to be vaccinated and submit to weekly testing. She claimed they were both prohibited by the Bible because they were toxic, and the vaccine was derived from fetal cells, which she said she had determined based on online research. Her exemption for the vaccine was approved, but she was not granted the exemption from the antigen testing, nor was she allowed to work remotely. So this was definitely a topic that we spent a lot more time reviewing during the COVID period. But if it comes up in your workplace, or maybe if you work in that healthcare setting where you do have mandatory flu vaccinations or COVID-19 vaccinations, keep this in mind. Religious accommodation also could come up when it comes to observing holidays. For some people, it's not working on Fridays. For some people, it's not working on Saturday or Sunday. Every time it has to be handled individually. The interactive process is required, and you look at that undue hardship analysis and whether there's an accommodation that will not be an undue hardship on the company. In this case, the plaintiff was terminated because she didn't comply with the mandate and she sued. At the district court, they granted defendant's motion to dismiss and the plaintiff appealed. And the Ninth Circuit ultimately affirmed, holding that while her beliefs about the vaccine may be religious, her objections to the testing were based on medical research and therefore not secular in nature. So again, just a takeaway, a reminder about the interactive process that's required not just for requests for accommodation for disability, but also for religious purposes. The next case is the case that I had mentioned. I wanted to include this because I talked about the regular rate of pay calculation. So this case is actually about calculating paid sick leave for outside salespeople. So it is pretty narrow. Next slide, thank you. It's pretty narrow, but I wanted to incorporate it because one, if you have any outside salespeople, you want to look at this case in terms of how they should be paid for paid sick leave. Outside salespeople have to be over 18 and they have to spend more than 50% of their time out in the field making sales. And that's truly out in the field. It's not working remotely. It's not working from Starbucks. It's knocking on doors, attending conferences, which again happened a lot less during COVID and post-COVID, maybe even with all the remote connection. But if you have somebody who truly is an exempt salesperson, you need to have that agreement in place. And you want to make sure that you're paying them paid sick leave as required by law. I'm going to jump to the next case just in the interest of time. I want to make sure we have enough time to go over questions. So this case is Bradsbury versus Vicar Operating. And the takeaway from this case has to do with meal period waivers. So as I mentioned, meal periods are required for non-exempt employees. They have to be provided 30 minutes duty-free for before the end of the 5th hour of work. However, there are 2 exemptions or 2 waivers that can take place. If an employee works no more than 6 hours, they can waive their meal period. So if you work between 5 or 6, you're technically entitled to a meal period, but you can waive it. If you work between 10 and 12 hours and you took your first meal period, you can waive voluntarily your second meal period. What a lot of employers have is a written meal period waiver that employees sign once, maybe while onboarding, maybe when they get their employee handbook. and they put in the file and they use that as their documented waiver. The plaintiff said that those waivers could not be prospective and that they were not proper because of that situation, that they had to be done each day that an employee wanted to waive a break. Thankfully, the trial court agreed with the employer and said that prospective meal period waivers are permitted as long as they are clearly written, voluntary, and signed. Employees have a right to revoke them, and they're not signed under pressure or coercion. What I want to impress here is having current updated meal period waivers in writing. If anybody wants to see a current version, Angela and Kristen might have a version. I'm happy to share a version. I think it's a great time to recirculate that as well. And also, it's a good opportunity to look at how are employees confirming that the time that they recorded was accurate and complete, and they didn't work any time that was not taken or that was not recorded. So having maybe attestation language at the end, either on a time card or when they review and submit their time for the pay period, saying all those. We use that a lot in litigation where an employee has signed off every pay period to say they didn't work off the clock, they recorded all time taken, they took all their meal breaks as required by law, they took all their rest breaks as required by law. If they didn't take a meal break or a rest break as required, it was voluntary. So all that language is really helpful in proving a claim about meal breaks, rest breaks, timekeeping, payroll, and so forth. We can go ahead and skip the next case and go over just very, very briefly to the Velarde. We'll skip Hearn. And this case talks about arbitration agreements. And I just want to add just a quick minute on arbitration. There are definitely pros and cons to arbitration. The pro is that you don't have that risk of that $1 million runaway jury verdict. You're in arbitration, usually with a retired judge who makes the decision based on the law. Usually, juries often will make emotional decisions or based on other factors. The downside is that employers in California have to pay the additional cost of arbitration. And arbitration agreements themselves are often litigated in terms of enforceability. So if you have an arbitration agreement, number one, I do recommend for most companies that they have arbitration agreements. And another huge benefit is that you can break up a class action. So you can have a class waiver, and you should have class waiver language in your arbitration agreement. And then you can force that person individually into arbitration, and you would stay, if it comes with a PAGA claim, you would stay that. So I do recommend arbitration agreements for almost every employer. And if you ever want to discuss further whether it's appropriate for you, I'm happy to. But it needs to be a current and enforceable arbitration agreement with all the language that we need to have in it today. And we tweak and update our arbitration agreements very regularly. So if anybody has questions about that, if anybody wants to take a look at an arbitration agreement, I'm happy to share that as well. And I will just mention the next slide, which is still pending. The Camp versus Home Depot case talks about rounding and timekeeping. And we're waiting for a decision from the California Supreme Court, but I would say let's not do rounding on our timekeeping anymore, because my feeling is that this case is going to come down and say that rounding is not permissible. And we never, ever want to round our meal breaks. So meal breaks should never be rounded to the nearest anything. And that sums up the case law. So I'm happy to leave a little bit of time for the questions, because I know that there's like quite a few questions here that are fantastic for us to go over.
Okay, well, thank you so much, Nicole and Kristen. Fantastic information for us. And this does bring us to the end of our presentation, but we are happy to see, we'll ask Sarah to help us to see what is in our Q&A.
Yeah, great. Thank you, all of you ladies, for that information. We're going to start back at the beginning. So talk about minimum wage. There was a question regarding, does the minimum exempt pay amount of $70,304 pertain to remote workers that do not live in California?
I can start with that, and then Nicole, you can certainly correct me. So we're back on slide 8. And for Minimum wage, it's based on where they're physically working. So if somebody's remote, then be based on whatever minimum wage is in place for their location, assuming they're doing all of their work at that one location. Nicole, did I get that right?
Yeah, absolutely. So I'll just add to that. So usually the laws of the location where the employee works apply. If you have an employee working out of state, you're going to be looking at any requirements in that state or federal law. And just to also add that the minimum wage threshold, or sorry, the exempt salary threshold is based on the state minimum wage, not any local minimum wages. So, Kristen, you talked about all those local minimum wages. Those don't apply when we're talking about that salary threshold.
Great.
All right, and then moving on to AB 692, the stay or pay. There was a question, does that pertain to agreements that were signed before January 1st, 2026?
Good question. So for the group, we're back on slide 11, and we did include a bullet there, but it's great to certainly point that out. So this applies to employment contracts entered on or after January 1st next year. So if you already have a contract in place, this does not apply retroactively.
All right, thank you. Okay, thinking about the personnel records, SB 513. This company, they document most of their training, but they also do a lot of on-the-job training that is not documented. Is that part of this recording that has to be on file, or is it just things that are HR related?
I can tackle that one. I have not seen a clear definition of what education and training includes or anything come out that would limit that. So I think the most important thing would be to think about how that on-the-job training um, is conducted in terms of if it's just observing and exposure or if it's actual training. Like for example, if there are milestones they have to hit and like they're doing it on the job training, and in 30 days you expect them to know how to use a cash register and know how to open and close, then maybe you have a checklist. So you could be overly conservative and say, during this period from, March 1st through March 20th, they were trained on opening and closing procedures, which includes, and then you could list those out. Um, I, I think here, though, it is a fine line. I'll let Nicole comment on where you might draw that distinction.
Yeah, I mean, I think you're absolutely right, Angela. There's every time we get these additional statutes that try to help clarify, it actually creates a lot more questions. And so I think with these situations, you definitely have arguments that you can make, and it's not going to be crystal clear, in terms of what documents to include there. But in litigation, that's a different story where we're talking about discovery, and then all of those documents will be free game.
All right, thank you. Moving on to the pay equity and the California pay data reporting. Angela, you mentioned that is reported on the Civil Rights Department portal. Is that just
That
an
is
online
correct.
website?
Yes, Department of Civil Rights. If you have reported before, you'll get reminders. You'll get an email reminder each year. But if you haven't, you can also register there and file for the first time there.
Okay. And does that reporting apply to transportation companies? Do you know?
I don't have any reason to think that it doesn't apply. It just depends on how big the transportation company is. So if we go back to, I don't remember which slide that was, but basically, if the transportation company is, they're under 100 employees, then they might not be required, but you would look at those requirements. That
Got it.
one's not carved out by industry.
Perfect. Thank you. In regards to record keeping, Nicole, you mentioned that 4-year term now applies. Can old terminated employee files be destroyed after that 4 years, or is there another recommended time frame?
So there are a couple other laws, and Angela and Krista, I love your thoughts on this too, but there are a couple other laws that require documents to be maintained for longer periods. Cal OSHA has some, there's some others, but in general, for time records, for payroll records, and for personnel, a minimum of 4 years. But I'd love to hear if you advise clients additionally.
Honestly, I save records for a long time. I save the whole file for about 10 years and before I'm ready to purge it.
Yeah.
because there's so many things that you might have put in there, especially if they were older. I used to, I mean, we don't have paper files anymore, but when I first started here, there was a lot of paper files. And because I didn't even know what was in them, what
Hmm.
could be called upon, you don't know what statute of limitations is going to apply to the mystery file. So
True.
I saved them for 10 years conservatively, not knowing what could be in there. And that is at which point I purged them. Now that things are electronic, it's a little bit easier to search and find where things are. So you
Right.
could probably give yourself some grace there. But if you still have paper files, it could take some time to really inventory what's in there. So
Yeah.
you may want to hang on to those for a bit.
I think that's such good advice. And the other thing is to look at your policies with regard to um, maintaining your email and your Slack message and your Teams chats, because those come into play almost every time in litigation. And so if we have some sort of procedure where they're not retained after 90 days or something like that, that can really hinder, good, bad, and ugly can come out, but we want to know what's in there.
Great, thank you. Moving on to PAGA, there's a question regarding the split shift being a potential PAGA claim. So in this scenario, if an employee works their full shift, then goes home and is called back to help with an emergency, but given the option to return and they choose to, is that considered pay for a split shift situation?
Okay. So if they do return a second time, then split shift requirements do apply. Um, let's see if they have the option to come back or not come back, but they return. Yeah, would you consider? So yes, even though it's optional, if they return a second time, then I would trigger that split shift requirement. Um, and or actually the reporting time pay too there. So take a look at both those things. Now, split shift can be offset by if an employee's paid more than minimum wage a certain amount. So a lot of times you're gonna have that offset, but reporting time pay is what I would look at there. Sarah, I'm happy to jump in on the other wage and hour questions
Sure,
if
go for it.
so do you have to pay rest break premiums even if you make those breaks readily available, but the employees choose not to take them? Really good question. So the law requires employers to allow employees to take their break, provide their break, not interfere with or impede or discourage employees from taking their breaks. If an employee voluntarily chooses not to take a break, there should not be a premium. The issue is going to be proving that. How do we show that, right? That it was their choice. So in order to do that, we need to have some sort of documentation. We need to have an acknowledgement. We need to have some sort of form they've filled out. And certainly if an employee comes to you and says, I couldn't take my break because I had a deadline or we were, couldn't shut off the machines or whatever it is, in that case, you do want to pay the premium. For meal breaks, if a person works over 12 hours, I believe they're entitled to an additional 30. Is it legal to offer an employee a blanket waiver to document? Okay, so it's the second meal break comes in. So we're looking at the 5 hour period. So for the second one, it kicks in at 10 hours. If they work no more than 12 hours and they took the first one, then yes, you can have that waiver in place for the second meal break. And that's usually in the form that I'm mentioning, the meal break waiver form that will document both the first meal break if they work no more than 6 hours and the second one in this situation. So yes, definitely having a waiver in writing that can be revoked if the employee chooses, that they voluntarily sign, is a very, very helpful document.
Great, thank you for addressing both of those. We had a question in response to the Kreutzbach's case. I'm probably not saying that right. Asking, can we set a policy where the company does not condone outside engagements?
Okay, so if we're looking at it in terms of personal relationships, we can have policies that address personal relationships in the workplace. For example, a supervisor cannot be in a personal relationship with somebody that they're supervising, or that it has to be disclosed to the company. And this can be family relationships, it can be romantic relationships. So we do want to be careful because we don't want to interfere with lawful off-duty activities. But if it's impacting the workplace, if it's coming into the workplace, or if it's a kind of a supervisor subordinate type situation, or even just peers, where there might be a morale issue or a potential favoritism issue, yes, the company can address it.
All right, thank you. Is there a recommendation for handling biweekly pay for salaried employees considering the uncommon 27 pay periods and biweekly pay cycles? That a relevant question.
Biweekly pay. So salaried employees, they can actually be paid once a month. The 2 times a month is for non-exempt hourly employees, and I never like to see a non-exempt employee receiving a salary. So assuming we're talking about exempt salaried employees, we can, if lawfully have a once a month pay, it has to meet certain criteria. I'm trying to follow the exact question. Feel free to jump in, Angela or Kristen, also.
And we have the name of that particular recipient.
Okay.
Maybe we'll just reach out to them specifically.
Yeah, definitely.
Okay, I do want to acknowledge the time. We have a handful of questions left, but I want to be sensitive to people's time frames. So if the three of you are able to stick around for a few more minutes, we can wrap these up, but I want to give people an opportunity to leave if needed.
I can stick around.
Yeah.
All right, everybody on the call, you're welcome to stay. If not, we'll get you the recording. All right, I'm gonna bounce around here a little bit. For training documentation, would it be appropriate to have a checklist, for example, like onboarding tasks?
What's the question? To have a checklist for your onboarding?
For your training documentation.
If any, I'm not sure. I think a checklist is a good idea always, if that helps you. And the checklist would have all of those things in it that you want to make sure that you document from the training, like the time, the date, the instructor, the duration, and the learning objectives and any certifications. As far as like in the new hire orientation part, if you do training during that time, like for example, part of our new hire orientation is HIPAA training. So it's just baked in there with all the other things. They're going through their stuff and then they're like, oh, I have to take this, I have to take that. So it's something like that. The HIPAA training, you bet, I'm carving that out. But not necessarily all of their onboarding elements, like reading about, unemployment or workers' comp. I don't consider that a training, but.
All right. We had a question about including pay range in job descriptions. So we often post a job brief on our website, which does not include a pay range. However, when we send serious applicants the actual job description, it includes the pay range directly. Is that compliant, or do they need to have that pay range in the full job description publicly posted?
Nicole, can you help with that one?
Gonna look at, we sent
Did you catch it? So we're back on job postings.
Mm-hmm. Okay, so you don't have to post the job description. If that's the question, you have to post the salary or the pay range.
Correct. They're asking if the pay range needs to be included in the job posting publicly.
Yes, it has to be in the job posting. Or do we need to have the actual full job description posted public? Is this compliant? I see. So it looks like they have the salary on the job description that they send to what they consider serious applicants, but not in the job posting.
Correct.
Yes. So yes, let's include it in the job postings. But we do not have to include the full job description. So maybe it would be working with, Angela and Kristen on revising those job postings so that they meet the requirement, but you don't have to provide, everything in the kitchen sink on that posting.
Yeah, I see a lot of employers actually doing this where the posting itself doesn't have the pay on it, and it should. But then you click through it. Once you click on it, it takes you to maybe their internal, HRIS system or ATS system. And then once you get inside, then you see it.
You can find it,
So
but they make you
not
work
on the
for it.
actual posting itself that ZipRecruiter or Indeed is putting out there to the public. So I see that a lot.
Mm.
All right. There was a question of the documentation for an employee volunteering not to take the meal break. Is that simply a form that they can sign and that you keep in their record?
Yeah, so it should be some sort of documentation. It can be a form. It can even be, sending an email confirming on this day I chose not to take a meal break and keeping that in the file. There's no kind of requirement as to what the documentation looks like. We just want to be able to prove that it was their choice.
I can add to that. There's sample templates on the mineral site for both that first and second meal break waiver.
Great, that's a great resource for our clients to use. I think we're going to wrap it there. Again, if we didn't address your specific question, please reach out to our team. Angela will wrap us up here and get us going.
Yeah, thanks everybody for attending today, and you will receive an email in the coming days with a recording, copy of the slide deck, and if you have additional questions, and I saw there was a question there about how do we reach out to Nicole, so in case anybody else had that question, you can see we have it here on our last slide, and you know how to find both Kristen and I at HR Compliance. Use our general HR Compliance. You can call us and ask, or you can use our HR Compliance at morrisgaretano.com to reach out with questions, and we'll be sure and get back to you as soon as we can.
Okay, thank you, everybody.
So much.
Thank you, everybody. Have a great day.
Bye.
Bye.